Assalamu alaikum. It's a great pleasure to be here. I'd like to thank Dr. Mira, Dr. Ghaffar, and of course, Mr. Mogira. What I propose to do is talk about a very specific topic, a doctrinal topic called Estoppel, and how it is developed in investment arbitration. What I'll do in the short time that I have is I'll begin with the definition of Estoppel, and then I'll briefly look at how the jurisprudence has developed, and then look at the ramifications of this concept. Of course, all of us, many of us here are lawyers, and of course are familiar with the general concept of Estoppel, but it has a very interesting thing we need to learn, particularly from international law perspective. The first thing I begin with is a quote from James Crawford, a very prominent arbitration international law specialist who sits on the International Court of Justice. And this is what James Crawford says. He says, an estoppel is precisely not a unilateral act. Not a unilateral act. It is a representation, the truth of which the entity on whose belief it is made is precluded from denying in certain circumstances. So the key thing here we need to focus on is preclusion. Estoppel is about preclusion. Basically, the simple way to think about it, I think, is it's a shield. It's a shield against a sword. That's all it is. It's estoppel. There are some other concepts that are related to estoppel. And one is a very often cited Latin phrase, and I'm no expert in Latin, but it's allegans contraria non addiendus. What does this mean? It's very simple. A person adducing to the contrary is not to be heard. If you say something contrary, we're not going to hear you. You cannot say something is hot and it's cold at the same time. If you say it's hot, it's hot. You can't say it's cold. This is related, of course, to the general concept of good faith. And good faith is often considered the basis of estoppel. Moving on, estoppel is also oftentimes talked about with various other concepts. And of course, among them are things like waiver, acquiescence, and recognition. And there's a lot of overlap in these concepts at many times, and sometimes they can exist at the same time. If we try to distinguish, one way to think about it is, waiver is something where you're giving away your rights. And recognition and acquiescence can actually create obligations. But again, as we said about estoppel, estoppel is just the shield. It's just preclusion. You're not necessarily giving up a right or creating an obligation. It's just the shield against the sword. Now, this is the classical, traditional definition of estoppel that's been developed by the International Court of Justice from a public international law standpoint. It requires three things. It requires that there be a clear and unequivocal representation of fact. That's the first prong. The second prong is it has to be voluntary. This representation made by someone has to be voluntary, unconditional, and authorized. That's the second prong. The third prong is where a lot of the debate occurs. The third prong is this representation has to be relied upon in good faith to the other party's detriment or the advantage of the party that made the statement. The big debate that goes on right now about estoppel is whether the third prong should be included or not. The traditional classical view is you have to have all three prongs. Some, however, debate, and many tribunals we find have actually not considered the third prong. And they think the first prong and the second prong is enough. I will call that the broad view, the traditional view versus the broad view. Moving along, looking at the first prong, it's supposed to be a clear, unequivocal representation of fact. What's the representation? Representation can occur in many forms. It can occur by word, someone can say something. It could be by conduct, by how a party has conducted themselves. Or it can be by silence. It can also be considered a representation. If we look at the second prong deals with the representation. But how is it represented? And who made the representation? A simple example would be if a firefighter or an aircraft controller made a representation. Can we consider that a representation on behalf of a party, of government? Probably not. Taking a look at the third prong is about reliance. And the reliance has to be reasonable. Some would say it has to be foreseeable. If you say, it's going to snow in the summer, nobody's going to believe that's not reasonable. It has to be a reasonable reliance and has to be a foreseeable reliance. Now, estoppel can occur throughout the process of arbitration. It can be at the jurisdiction phase, it can be at the merit phase, it can provide procedural issues, it can involve quantum, it can involve the annulment process. Throughout the arbitration proceedings, estoppel arguments are made. So it's constantly made all the time. And it's made, of course, by claimants and respondents. Both sides make estoppel arguments to each other, using that shield. Another debate occurs that some tribunals, investment tribunals, have actually considered estoppel for representations of law. And we have seen this, most recently, for instance, in the Yukos case, where representations of law were considered a shield for estoppel. And of course, some are critical of that. As we saw, the traditional view is no, it's only for representations of fact. So I close with an interesting case, the most recent ICSID case involving estoppel. In a 2011 case brought by company investor Cambodia Power against Cambodia. We have a very eminent tribunal, Neil Kaplan, John Beachy, and Toby Landau. And what the claimant tried to do is they wanted to include a state entity as one of the respondents. Now, under ICSID practice, what's supposed to happen is the state, Cambodia, is supposed to designate all the agents of its government. And only those agents could be potentially brought in as a respondent. So the claimant's argument was, no, they wanted to use the shield. You cannot deny that that entity, the state-owned enterprise, should not be included. We've basically designated that entity, so they should be included. That was their argument. So you should be stopped from denying it. You can't use your shield to deny my argument. Interestingly, the tribunal dismissed the case on all three bases, all three prongs. I'll only focus on the last prong, though. The last prong was there was no detriment. Why was there no detriment? It's very interesting. Their argument was if you exclude the state-owned entity, you will still have recourse. You can still bring a private, separate claim outside of ICSID, an ICC claim, against that party. So you don't have any detriment if we exclude the entity from the exit claim. Therefore, no detriment, among other things, so they denied the Estoppel argument. The conclusion is that for the investment tribunals that adopt the traditional approach of all three prongs, consistently so far what we found is, if they adopt all three prongs, they'll deny the Estoppel argument. If they adopt the broader approach, it only applies to two prongs, the first and second prong, however, we find a mix. Some tribunals have accepted the Estoppel claim, our shield, and some have not. So this is what we have to look for in the future as to whether this will be a trend, whether tribunals will continue to adopt the traditional approach, or whether they'll go more toward this broader approach that only considers the first two prongs. Thank you very much.